this was when I read this case, which was handed down in September 2022. I found it rather disconcerting, to be fairly honest, and this attempt to void the contract through the doctrine of, or doctrine, I don't know exactly how you say that, the doctrine of common mistake. So I know John Lobb because I'm French, so I go to Paris quite often, and I also live in London in England. So I know that for Parisian men and also for Englishmen, John Lobb is a superb brand of beautiful footwear. And I really love John Lobb. I think they do a great job. So I was, of course, very interested and intrigued by that case. And I had always wondered how basically they structure their affairs, John Lobb, and between France and Paris and London. I had always wondered. Well, this actually case gave me a good understanding of how they work or don't work, don't really work. So I did an exhaustive review and analysis of England and Wales High Court Chancery Division decision dated the 8th of September 2022. On whether the agreement bounding the French business, which is John Lobb SAS, to the British business, which is John Lobb Limited, was void under the case law of common mistake. And was it a good call for John Lobb Limited to pull such a claim? Did John Lobb Limited gain anything out of his public exposure and this washing of dirty laundry in the public eye through this court case? I don't think so, and here is why I have reservations as to whether it was a good move. Now let's talk about the facts. Oh yeah, much better. So let's talk about the facts. Well, so John Lobb is, as I said, is a men's luxury footwear brand, and it's worn by many celebrities in their time, so such as Cecil Beaton, Orson Welles, and Catherine Hepburn. It was founded in Sydney, Australia, in 1849 by John Lobb, who was a Brit from Cornwall, and who had emigrated to Australia, and it was actually the son of a farmhand. So he really made himself and his whole family definitely go through the social, the upper echelons of the social ladder, because he was the son of a farmhand and he created this thriving business, you know, single-handedly back in the 19th century, originally in Australia. It's actually interesting to note that quite a lot of luxury fashion businesses were in this area created out of Australia. For example, Helena Rubinstein, who was originally Polish, if I remember well, and they had to move out of Poland, her and the family, but basically she immigrated to Australia, and this is where actually she also founded the cosmetics brand Helena Rubinstein. And there was another example which sprang to mind when I was writing this article, also in the fashion and luxury business, but I must admit I can't remember. Anyway, so John Lobb, same story than Helena Rubinstein. He created his business out of Sydney, Australia. However, in 1866, the business moved to London in the United Kingdom and began trading from premises located at 296 Regent Street. In 1946, the business was incorporated by Eric Lobb, a descendant of founder John Lobb, and it was incorporated into Société John Lobb after the successful setup of a boutique located Rue du 29 Juillet in Paris around 1900. So what happened is probably because the French were a bit more uptight on this, they decided to incorporate the French branch into a subsidiary, John Lobb France. And in September 1972, Eric Lobb incorporated the shoemaking business into John Lobb Limited, a private company limited by shares in London.
The share capital of GAL, John Lobb Limited, was and still is £10,000 divided into 10,000 shares of £1 each. Eric Lobb and John Hunter Lobb, master bootmaker, seem to have been the two shareholders of GAL upon incorporation in 1972. The 5 original directors of GAL were mostly members of a family, except John White, a bootmaker. So there was, of course, Eric Lobb, but also John Hunter Lobb, Alice Margaret Ellen Lobb, and Edward Eric Lobb. So really a family business. GAL shares are still now held by various members of the Lobb family. You can check that on the Uncorporate, the website of Companies House. In 1976, the majority of the shares in JLF, so John Lobb France, was sold by Eric Lobb to the French luxury goods business Hermès, French business Hermès. Hermès acquired control of John Lobb France, as well as the rights in a trademark registered in France by Eric Lobb, which protected JLF's products. So we're going to call it from now on the trademark. Meanwhile, John Lobb France was transformed into a Société par Action Simplifiée, or SAS, and continued developing and operating its own luxury footwear business under the steady hand of Hermès. And the general manager of Hermès, Guillaume de Seine, is also currently the CEO of John Lobb SAS. So, and you can really see actually the synergies between John Lobb and Hermès, because they both do provide lots of leather products, very high quality leather products. So it does make complete sense for, you know, the top management of Hermès to also be involved in the John Lobb France business. From 1976 onwards, there has been collaboration between the businesses of John Lobb Limited and John Lobb SAS. Indeed, John Lobb SAS operated and continued to operate its business selling footwear under the John Lobb name. Hermès started registering international trademarks around the world, which were international extensions of the trademark I mentioned before, in order to protect the John Lobb brand. So together, all these international extensions of the trademark are called the trademark portfolio. From now on, we're going to call them the trademark portfolio. So in order to regularize this collaboration, as well as clarify the rights of John Lobb Limited and John Lobb SAS into the trademark and the trademark portfolio, GAL and GAL SAS, together with Eric Lobb, entered into a written agreement on the 9th of March 1992, called the Radlett Agreement. Already, signs of poor legal drafting services rendered were identified into the Radlett Agreement, since Clause 10 of the Radlett Agreement set out that it was entered into for a period of 15 years, at which time its operation shall be reviewed by GAL and GAL SAS. And such Clause 10 did not specify a start date for this 15 years period. However, Clause 9 of the Radlett Agreement, which related to financial matters, set out that the Radlett Agreement was entered into from 9th of March 1992. So that means that around 2017, then the Radlett Agreement would come to an halt. Let me double check that. We said 15 years and it started in 1992 plus, that's right, 2007, apologies. In 2007, it was due for renewal, the Radlett Agreement. The recitals to the Radlett Agreement set out that the property rights in the trademark were ceded, I quote here, ceded by Eric Lobb to John Lobb SAS, pursuant to an agreement between the parties dated 24th of May 1976, so the prior agreement, in consideration of a payment of a percentage of John Lobb SAS turnover for the years between 31st of March 1976 and 31st of December 1985. The trademark was registered in other countries, hence creating the trademark portfolio, and recorded the costs incurred by John Lobb SAS in this respect. And the last recitals was that the parties wished to continue to collaborate and, I quote here, extend existing agreements to the manufacture, promotion, and sales of products described in classes and categories of a trademark already registered throughout the world. So through various clauses, the Radlett Agreement gave John Lobb SAS the right to the manufacture, promotion, and sales of ready-to-wear footwear under the trademark throughout the world. But such right was limited under Clause 2, since John Lobb SAS agreed not to manufacture made-to-measure handmade footwear in the UK under the trademark and assign to John Lobb Limited any rights which may have accrued to John Lobb SAS in the UK by its acquisition of a trademark in made-to-measure handmade footwear. So that means that John Lobb SAS had rights on the trademark throughout the world, but not in the UK, because in the UK, only John Lobb Limited could use such trademark. And so in exchange for this permanent assignment of a trademark, the Radlett Agreement provided that John Lobb SAS agreed to make annual payments to John Lobb Limited, which were expressed to be in consideration for extending the prior agreement in accordance with terms and conditions of a Radlett Agreement. Again, this is, poorly drafted, not very clear. So there were some supplementary provisions also in clause 6 to 9, and these provisions were for payment to John Lobb Limited, and they were actually amended when Hermès acquired Edward Green and Company Limited, another luxury UK footwear manufacturer. The sums payable to John Lobb Limited were increased to take into account the increase in turnover resulting from this acquisition. So Clause 11 of the Radlett Agreement provided that it was governed by and construed in accordance with the laws of England and Wales. And, that was fine for Hermès, because Hermès is is an international business. The English laws are trustworthy, efficient. The English court system is also efficient. So I'm sure Hermès and John Lobb SAS were absolutely fine with that. And since the termination of a Radlett Agreement was planned to take place in March 2007, as I mentioned before, 2007 was the cutoff date, negotiations between the parties kicked off in late 2005 concerning the nature and terms of a relationship between the parties, which was to follow the Radlett Agreement. So on March 2006, John Lobb SAS solicitors, DLA Piper, sent a letter to Hermès which contained advice, quote here, in relation to your rights or ownership and use of a trademark. So in this letter, which was copied to GLL as John Lobb Limited as part of the negotiations, it was set out, as I said at the outset, while there have over the years been a number of agreements and discussions between the parties, Hermès ownership of a trademark is well documented. John Lobb Limited has received proper consideration for the acquisition by Hermès of those exclusive rights, and Hermès is entitled to continue to use, exploit, and protect those rights as any trademark owner would be. Okay, so for the letter, DLA was just saying Hermès owns the right to the trademark, and we're going to continue exploiting those rights. And now let's talk about the agreement. So on the 6th of March 2008, John Lobb SAS and John Lobb Limited, as well as the shareholders of John Lobb Limited, entered into an agreement organizing the future relationship, which was entitled, and I quote here, agreement relating to John Lobb name and trademark. So that from now on, we're going to call it the 2008 agreement. So this 2008 agreement provided that the prior agreement dealt with the sale of a trademark. The trademark was registered for its protection in various countries by John Lobb SAS. John Lobb Limited and John Lobb SAS had fully cooperated to maintain and develop a mutual business built on the trademark and trade name Lobb, with a view to ensure that standards continue in the future. And John Lobb SAS is the legal and beneficial owner and registered proprietor of a trademark throughout the world, and has all the rights in the trademark, save in respect of the rights enjoyed by John Lobb Limited set out in Clause 1. of the 2008 agreement. And this is in relation to the rights that John Lobb Limited has in the UK over the trademark. So pursuant to clause 2 of the 2008 agreement, John Lobb SAS would make annual financial payments to John Lobb Limited over 2 consecutive periods of 5 years, and a first annual payment for the period from March 2007 to March 2008, and the final annual payment of £35,000 fell due for payment on or before the 10th of March 2017. There were 5 annexes to the 2008 agreement, in particular Annex B, which set out a list of the trademarks registered in various countries, which corresponds to the trademark portfolio I mentioned before. So from 2008 to 2017, the parties operating under the terms of the 2008 agreement without issue. However, on the 19th of April 2017, so shortly before the payment of £35,000 was, actually it was due on the 10th of March 2017, but so on or around the time payment of £35,000 had to be paid, John Lobb Limited solicitors Clintons sent a formal letter of claim to DLA, John Lobb SAS counsel, and in this letter of claim, it set out the grounds of challenge to the validity of a 2008 agreement and asserted that it was void on the basis of common mistake. What? Common mistake? So the procedure that ensued is as follows. Since, I quote here, some reasonable endeavors to resolve problems through discussion at senior management level apparently failed, John Lobb Limited started litigation proceedings by claim form issued on the 22nd of May 2020. John Lobb Limited's case is that the 2008 agreement was void from the outset on the basis of common mistake, and John Lobb Limited is the beneficial owner of a trademark portfolio, with the exception of a trademark. So GLL particulars of claim were amended via some amended particulars of claim. Actually, just, for the record, I'm just mentioning this. So in these amended particulars of claim, paragraph 26 set out that the 2008 agreement was entered into by both John Lobb Limited and John Lobb SAS on the basis of a fundamentally mistaken and commonly held belief as to the ownership rights in the trademark portfolio. And so the alleged common mistake, which is relied upon by John Lobb Limited, is, I quote here, a fundamentally mistaken and commonly held belief as to the ownership right in the trademark portfolio. So to beef up its claims, John Lobb Limited set out in the amended particulars of claim that the letter contained the following material. So when I mentioned the letter, I mentioned the DLA's letter from around 2007, contained the following material sessions of facts. In 1975, Eric Lobb began negotiating with Hermes for the sale to Hermes of a majority of the shares in John Lobb SAS. Part of that agreement was to be the acquisition by Hermes of the rights to the trademark throughout the world. In March 1976, the agreement for the purchase of the shares was signed, and Eric Lobb confirmed that before he received any payment for the shares, he would transfer the trademark rights to Hermes John Lobb SAS. Consideration for the transfer of the trademark rights was installment payments calculated as a percentage of turnover payable over a number of years from 1976 to 1985. And between 1976 to 1992, John Lobb SAS, exercising its acquired trademark rights, applied for registered protection for the trademarks around the world. In 1992, Eric Lobb, John Lobb Limited and John Lobb SAS entered into a further agreement, the Radlett Agreement, with the aim of confirming John Lobb Limited's rights to use the trademark only for the manufacturing and commercialization of made-to-measure handmade footwear, and confirming John Lobb SAS exclusive rights to everything else. So then John Lobb Limited alleged in the amended particulars of claim that the letter contained fundamental errors of facts of his DLA letter contained fundamental errors of fact as follows. So the letter, the DLA letter asserted that in 1975, 1976, Eric Lobb agreed to transfer to Hermes and did so transfer the right to protect and exploit the trademark throughout the world, i.e. To assign to Hermes and to John Lobb SAS the entire worldwide goodwill and reputation in the John Lobb name built up by the predecessors in title to John Lobb Limited over a period exceeding 125 years. And according to John Lobb Limited in its amended particulars of claim, this assertion was manifestly false, having regard in particular to the terms of a prior agreement pursuant to which all that Eric Lobb was agreeing to transfer in terms of trademark rights was the trademark which John Lobb SAS required in order to conduct the French-based business which it was in substance acquiring. So accordingly, for John Lobb Limited, it was also incorrect that the consideration payable under the prior agreement was for the trademark rights as asserted and described in the letter. It was also incorrect that John Lobb SAS applied for registered protection for the trademark, exercising its acquired trademark rights. Accordingly, any agreement subsequently made between the parties to the Radlett Agreement, which reflected this wholly inaccurate series of factual assertions and which assumed John Lobb SAS ownership of a trademark portfolio, would not be one which accorded with the intention of the parties, but would be one which assumed a fundamentally different and false set of factual and legal premises, in particular to the ownership of the John Lobb marks outside France. And also the amended particulars of claim of John Lobb Limited asserted that the 2008 agreement was such an agreement. So to summarize, in a nutshell, John Lobb is saying it is actually a mistake, a common mistake that John Lobb Limited made back, when he did that prior agreement in the 70s. And the only thing that John Lobb Limited agreed to was the transfer of a French trademark to John Lobb SAS and to Hermes. But all the trademark portfolio belongs to John Lobb Limited, the UK entity. So that's, in a nutshell, is what John Lobb Limited is saying. Exactly. John Lobb case is that it only agreed to enter into the agreement because it believed to be true and accurate the assertions made in the DLA letter and the assertions made in the course of discussions by representative of John Lobb SAS as to the ownership of a trademark portfolio during the negotiations. And therefore, according to John Lobb Limited and John Lobb SAS entered into the 2008 agreement on the basis of a fundamentally mistaken and commonly held belief that John Lobb SAS owned the trademark portfolio on the basis of other reasons set out in the DLA letter and during the negotiations. So the true position John Lobb Limited contended in its amended statement of claims was that the beneficial ownership of the trademark was in fact vested in John Lobb Limited, with the sole exception of a trademark. And in its amended particulars of claim, John Lobb Limited proceeding on to asking for principal relief, declaratory relief, comprising a declaration that John Lobb Limited is not bound by the terms of a 2008 agreement on the basis that it is void from the outset for common mistake, and a declaration that John Lobb Limited is beneficially entitled to the ownership of a trademark portfolio, including the registered protections with the exception of a trademark. So, aghast, I suppose, John Lobb SAS and Hermes filed a defense in the action and made an application by application notice dating 4th August 2022, denying John Lobb Limited's right to any of the relief claimed as follows. John Lobb SAS sought as relief an order striking out the amended particulars of claim pursuant to 3.42a of the civil procedural rules on the basis that the amended particulars of claim disclosed no reasonable ground for bringing the claim. Okay, so this 3.42 of the CPR, of the civil procedural clause, is basically we want to strike out this case because there aren't any reasonable grounds for bringing or defending the claim. So that was the first branch of the defense of John Lobb SAS. And then secondly, John Lobb SAS sought as relief summary judgment against John Lobb Limited on the whole of a claim pursuant to Article 24(2)ai of the CPR of the Civil Procedural Rules, on the basis that John Lobb Limited had no real prospect of success on the claim and that there was no other compelling reason why the case should be disposed of at trial. So this clause 24.2 is the ground for summary judgment when there are no real prospect of success on the claim or issue. So basically, the defendant is asking to strike the claim off because it's not reasonable. So, and consequential on this relief, John Lobb SAS asked in his defense, an order for dismissal of a claim and cost was also sought by them. In a judgment dated 24th of May 2021, the High Court Judge, Deputy Master Marsh, concluded that John Lobb Limited had a real prospect of showing that the claim for a declaration of a 2008 agreement was void on the basis of common mistake, based on the 4 required elements of a claim based upon common mistake defined by the judgment of a Court of Appeal, which was delivered by Lord Philip in Great Peace Shipping Limited versus Savliris Salvage. It's called the Great Peace case. Great Peace as in P-E-A-C-E. So the Great Peace case. Okay. So interestingly enough, the judge and the first degree judge, the High Court judge, actually found that John Lobb Limited had a real prospect of showing that the 2008 agreement was void on the basis of common mistake under application of the Great Peace case law. John Lobb SAS was unable to show that John Lobb Limited's case on limitation was bound to fail because John Lobb Limited could not establish the second element or the 4th element identified in Great Peace. So that is another finding that Deputy Master Marsh made and set out in his judgment from May 2021. So he continued by saying that the first element identified in Great Peace for this common mistake doctrine, so this is the requirement that the parties have entered into a contract under the common assumption as to the existence of a state of affairs. So this is the first element. It was met. That first element was met. And then the second element identified in Greenpeace, which is that there must be no warranty by either party that that state of affairs exists. This is the second element. According to the High Court judge, that was met as well. Same for the third element identified in Great Peace, which is the non-existence of a state of affairs must render performance of a contract impossible. So according to Deputy Judge March, that third element was also met. Same thing for the 4th element identified in Great Peace, which was the state of affairs, maybe the experience or a vital attribute of a consideration to be provided. So the High Court judge also found that John Lobb SAS had not demonstrated that John Lobb Limited had no real prospect of success, and John Lobb SAS application was dismissed, both in relation to the application for summary judgment and the application to strike out. So, of course, and thankfully, John Lobb SAS appealed the first degree judgment on the following grounds. The judge went wrong in his approach to the doctrine of common mistake by failing to apply correctly the elements of the doctrine, specifically the second element and the 4th element as set out by the Court of Appeal in Great Peace. Also in its appeal, John Lobb SAS mentioned that the judge was wrong to reason that the 2008 agreement could not be construed on an application for summary judgment or strikeout, when it gave rise to a short point of law and construction, which was capable of being determined in the absence of any dispute for the purpose of John Lobb SAS application about the relevant matrix of act and or on the basis of the facts alleged by John Lobb Limited. So anyway, that's a wordy way to say that that basically the this request to actually make the 2008 agreement void could not be the base of an application for summary judgment or being stricken out. Then John Lobb SAS in its appeal also mentioned that the judge was wrong to regard the doctrine of common mistake as being insufficiently settled. And according to John Lobb SAS in its appeal, the judge misunderstood the fourth element as being concerned with something less than impossibility of performance of a contractual adventure, and instead treated this element as asking whether performance is essentially different to that common assumption. If the judge had correctly applied the law of common mistake, he would have been bound to conclude that there was no reasonable grounds for John Lobb Limited to bring the claim for rescission of the 2008 agreement, and should either have struck out the claim or should have concluded that John Lobb Limited's claim had no realistic prospect of success and was suitable for summary disposal. So anyway, in a nutshell, John Lobb SAS is saying in his appeal, are you mad? That's what it's saying. Are you mad? Of course, the second and fourth element of the doctrine of common mistake are not met in this matter, High Court judge, and this is sufficient ground to actually strike out this claim or just dispose of it. And both provisions we mentioned before of a CPR. And in a seminal appeal judgment handed down on the 8th of September 2022, Justice Edwin Johnson found for John Lobb SAS because the High Court judge decision in relation to the second element identified by Lord Phillips in Great Peace was inexact because a warranty on the state of affairs actually existed in the 2008 agreement. This is to say that the 2008 agreement sets out that John Lobb SAS is the legal and beneficial owner and registered proprietor of a trademark portfolio throughout the world and has therefore the rights in the trademark portfolio, save for the rights enjoyed by John Lobb Limited, set out in clause 1 of the 2008 agreement and relating to the the UK territory. Also, the appeal judge found that the 2008 agreement allocated the risk in the event that the assumption was wrong to John Lobb Limited by the combined operation of recital G and clause 1.3 of the 2008 agreement. I mean, between you and I, this judgment, this appeal judgment from the 8th of September 2022 is quite a mouthful to read. Okay, so that's why I called it a seminal appeal judgment. It's quite a mouthful to read, and it goes on and on about, super complex ways to assess whether the second element, the fourth element of the Great Peace case law relating to the doctrine of common mistake are met or not. And I will definitely not delve into this because nobody cares. But the outcome is that the appeal judge found that both the second and the fourth element were not met. And it was inexact to say that they were, because the alleged non-existence of a state of affairs did not either render the performance of a 2008 agreement impossible or render the subject matter of a 2008 agreement essentially and radically different from the subject matter which the parties believed to exist. And then the appeal judge also found that the claim that the 2008 agreement was void from the outset on the basis of common mistake could not succeed. John Lobb Limited had no real or indeed any prospect of succeeding in its claim to avoid the 2008 agreement on the basis of common mistake. The appeal judge also found that John Lobb SAS is entitled to summary judgment against John Lobb Limited, and there is no reason for John Lobb Limited's action to go to trial. Although this conclusion was strictly academic, the appeal judge found that on the summary judgment application, the first degree judge was actually right to decline to strike out John Lobb Limited claims pursuant to CPR 3.42a. So anyway, consequently, the outcome of the appeal was that the appeal was allowed on the basis that judge was wrong, the High Court judge was wrong to dismiss John Lobb SAS application so far as John Lobb SAS sought summary judgment against John Lobb Limited, And the appeal judge made an order for summary judgment against John Lobb Limited on the whole of its claims in the action, and the appeal judge made an order for the dismissal of John Lobb Limited's claims in the action. Let's analyze this case and the appeal decision and also the first degree decision and judgment. I mean, I think that what can definitely be said about these is that and also the attitude of the parties is that there is a total lack of self-awareness here from John Lobb Limited and its management, and also from its counsel, Clinton's. What on earth were they thinking, bringing this, common mistake doctrine from, out of the woods all of a sudden, while these various agreements had been in place since, the 20s, the 20s between John Lobb France and John Lobb UK. So I was just out of order, really. So before launching themselves into fully fledged litigation, John Lobb Limited should have assessed in an impartial, thorough, and rigorous manner whether they had enough ammunitions to put into the common mistake gun, instead of blindly following the intuition, let's call it intuition, of family member, qualified solicitor, and new John Lobb Limited's in-house lawyer, Nicholas Lobb, who joined the family business in 2013 and put this whole craziness into motion. I mean, the crux of the issue here is that John Lobb Limited wants out of the 2008 agreement, which is permanent, perpetual, and cannot be terminated, except in case of major change of share ownership in either John Lobb Limited or John Lobb SAS. So for just to clarify this, if the 10,000 shares from John Lobb Limited were to be sold to any external party from the John Lobb family, then Hermès would have a preemption right to buy those shares, and also this would trigger the termination of the 2008 agreement. And I think there's also a reciprocal clause for John Lobb SAS to the effect that if the shareholding of John Lobb SAS was to get out of the hands of Hermès, then that would trigger the termination of the 2008 agreement. So the issue here at stake is that the John Lobb family is stuck in this 2008 agreement, and they can't get out of it, except if they sort of sell out, which I suppose they don't really want to do. So probably like in the Chanel saga, so I refer you to my article and live webinar of last week in relation to how Chanel was set up by Gabrielle Chanel and her two co-owners, the Wertheimer brothers. And so you can actually read this article on Chanel on crefovi.com /publications in English and crefovi.fr/publication in French. So like in the Chanel saga, John Lobb Limited and the Lobb family want to get more money for the trademark portfolio and renegotiate the terms of the 2008 agreement in this respect. And well, I mean, okay, this is understandable because a lot of fashion and luxury businesses are coming out of the COVID-19 pandemic and the economic recession, feeling pretty raw, and a lot of them have cash flow issues, and even sometimes they actually have to close down and being wound up. At the moment in France, there are lots of companies in the consumer goods and particular fashion businesses which have to be wound up, such as Gosport and lots of French brands as well, Pinky, etc. They all have to close down because they're dead. But using the common mistake doctrine in this case was amateurish and naive at best on the part of John Lobb Limited and its counsel, Clinton's. The parties and signatories to the 2008 agreement, among them many members of the Lobb family, were all professionals and capable adults. They cannot seriously claim that they misunderstood the explicit and clear terms of the 2008 agreement, or for that matter, the terms of a DLA letter, especially in respect of the subject of which party owns which trademark. I mean, this is a stark warning to commercial practitioners like DLA and Clintons of the results of that ambiguity in legal drafting can cause, but also the significance where allocation of risk is found within a contract and the consequences this can have on the findings of common mistake, as the case is here. I think it would have been way more astute for John Lobb Limited management and legal team to enter into confidential and good faith negotiations with Hermès and John Lobb SAS in order to renegotiate the amount of the final annual payment of £35,000 due by 2017 by amending clause 2 of the 2008 agreement, and also potentially some other clauses in the 2008 agreement that they had come to hate and disagree with. They could have asked for additional annual payments to be made every 5 or 10 years of execution of a 2008 agreement, since its term is without any limit in time, i.e. this 2008 agreement is perpetual, except, as I said, in the case of external shareholding happening in both parties, either one of the parties. So this litigation case, which splashes out in front of the UK High Court and then the UK Appeal Court, confidential terms set out both in the Radlett Agreement and the 2008 Agreement, drawing public attention to the business of John Lobb for all the wrong reasons, is a public relations disaster for John Lobb Limited and, by ricochet, for John Lobb SAS. If good faith negotiations with Hermès and John Lobb SAS to renegotiate the payments owed to John Lobb Limited on the grounds of the trademark portfolio fail, then John Lobb Limited should bring a claim in court to request a renegotiation or termination of a 2008 agreement, which term is perpetual and without limit. In particular, they could claim that there has been an unforeseeable change in circumstances and or force majeure, and knowing that such reasons are valid reasons to negotiate a long-term contract in jurisdictions such as China, France, Germany, and Japan. So even though it's not in the UK a valid reason to negotiate a long-term contract, this unforeseeable change in circumstances or force majeure, it was, however, it could have been worth trying in front of the UK courts. But anything other than this common mistake, doctrine, stupidity, frankly, I mean, they really looked amateurish, John Lobb Limited and Clintons. So if a court claim fails, then it may be time for the John Lobb family to sell out by triggering clause 5 of the 2008 agreement and negotiate the highest payment they can get for all the 10,000 shares in John Lobb Limited from Hermès, which has a preemption right, or any other interested bidder. And I'm pretty sure if the John Lobb family wanted to get out of the business in the UK, Hermès would buy them no problem whatsoever, and probably at any price they would want. So that's my analysis on the this intriguing John Lobb litigation case, and I thank you so much for joining me today on this matter, and I'll speak to you next week. Bye, everyone. Bye-bye.